of the day, and I'm going to start over again. The title of the case is People versus Rosalind Ray Keenan. The allegation is that
This is one of those courtroom moments where you almost want to yell at the screen. The case of People versus Rosalind Ray Keenan starts with a felony resisting and obstructing charge, plus driving on a suspended license. But instead of tackling the charges head-on, Keenan launches into a legal philosophy that's instantly recognizable to judges, the kind of sovereign citizen language that challenges the court's authority. The problem? That almost never ends well for the person saying it.
On or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but prosecuting attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here as sui juris impropria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land. I'm here under fraud, menace, and duress. I am the private woman, Rosalind Ray
All right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime I autograph is to be done in a certain manner that I have here.
Signed her bond. She signed it as Rosalind Ray Keenan beneficiary with quick bail bonds. All right, now we've got another issue. This is a felony charge. The first one is. The second one is under the Motor Vehicle Code. And it requires that we have a preliminary examination, or it requires that you're entitled to a preliminary examination. We had a pre-exam conference last week, and you expressed at that time that you did not wish to have an attorney. You're here with you this morning without an attorney, and we'll address that in a moment. You've been talking with Mr. Marvin. You have an absolute right to represent yourself. I normally don't recommend it. Mr. Marvin will sit down and talk with anybody, whether they're an attorney or whether they're a layperson.
Here's where things get interesting. Most of the time, prosecutors are firm, even aggressive. But in this case, you can see David Marvin going out of his way to work with her. He's met her multiple times, knows her family, and is offering a deal that would wipe the felony off her record completely. That's huge. Felonies follow you for life. Jobs, housing, even basic rights can be affected. And he's basically saying, take this misdemeanor, stay clean for 6 months, and it's gone. Deals like that don't come around often.
So you and he have been meeting to discuss this. Mr. Marvin, is there a plea offer here?
There is. And I'll tell you about that, but I wanted to mention that this is, I believe, the third time we've sat down, and so this is dragged out a bit, but only because she's not represented, and in these 3 separate meetings and adjournments, the court has allowed those, and I appreciate it. I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it in hopefully 2 seconds. But what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's
is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor.
But instead of locking it in, Keenan says she doesn't understand the charge. And it's not the kind of, I need clarification, not understanding. It's a refusal to accept the premise at all. You can almost see the judge's patience. Thinning in court, timing is everything. Stall too long, and even the best deals start slipping away.
It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the charge.
All right, Mr. Marvin, let's just do a prelim. I'm not going to tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm going to have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What did you say about the?
It's a benefit. And
No, before that, about the license.
He's dismissing it, and it won't affect your driving privileges here or Michigan.
Well, I don't understand that.
Mr. Marvin, let's just put on a prelim.
Games. I'm serious.
You are playing games, and first of all, you don't.
I'm trying to advance to
all right,
what
stop.
I'm here.
You don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth. So.
All right. Well, this crazy stuff you're saying, I've got very little patience.
Then comes the jurisdiction debate. She starts asking if this is under common law, admiralty law, or military tribunal rules. The judge calls it wacky because, to be blunt, these arguments have no legal weight in this setting. It's a Michigan criminal case. State law applies. That's it. Whether you agree or disagree with the system, those are the rules in that courtroom. And ignoring that reality can turn a small problem into a very big one.
So, may I ask, what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case. Criminal case means you could go to jail, in this case, for up to 2 years. In a civil case, there's no possibility of jail. It's usually over money damages or other types of non-jail relief, like other types of non-jail relief. So yes, this is a criminal case.
Well, thank you. So, you said the record is on.
Yes.
Could the record of the court show that this is a criminal action? And my next question is, I know that the Constitution grants the court 2 types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these 2 jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
The judge is practically spelling it out. This could put you in jail. You have a way out right now. But Keenan's locked into her approach. It's like watching someone in a lifeboat throw away the oars because they don't like the shape.
The conduct in here in the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first. Well, first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct. So to further comment on Mr. Marvin's offer, if you pled to the charge of attempted resisting and obstructing a police officer, he offered to defer the sentence for 6 months, and if there were no further problems, to dismiss it, which is very generous based on the police report bond information that I came.
I know I can peer for myself. I'm competent and I am confident. Okay?
All right.
So
The next question is, are you
Please.
willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. I have the right to peer for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure
All right,
under
stop.
admiralty or military
Stop.
tribunal venue.
Stop. We went through this before.
I know.
This is not civil
It's the
procedure.
Sixth Amendment grants me the right to know the jurisdiction being applied,
And I told you what it was.
and it gives you the duty.
All right, stop. If you interrupt me one more.
And then it happens the breaking point. In court, interrupting a judge is a dangerous move. Do it once. You might get a warning. Do it twice. You're pushing your luck. Keenan keeps talking, and the judge warns her. When she keeps going, that's it. Contempt of court, custody, 24 hours in jail, on the spot. All over arguments that were never going to change the outcome.
All the property from you, ma'am, and whatever property you want to release to your son, I'll be more than happy to. She's going into custody for contempt.
Hey, let's go this way.
And then let's watch out for this chair here. There we go. Go ahead and watch your foot. There we go.
So, that's it then, is court over?
Yeah, we're done.
Can I say something?
Yes?
I don't think that she was trying to be in contempt of court. She was trying to exercise a right. And I think it was just a misunderstanding of how for her to be able to pronounce that. But,
Well, I told her to stop, and she didn't stop, and she doesn't know what she's doing. She needs a lawyer, and she's going to contempt herself into 90 days if she doesn't be careful. So we'll address this tomorrow at 3 o'clock. And to whatever extent you're advising her on this stuff, you're not doing her any favors. Mr. Marvin gave her the sweetest deal where she could not have a charge on her record, and all she wants to do is argue about admiralty law.
please have that record still, or that chart, that option still, if I talk to Mr. Marvin.
Yeah, I guess so. Well, you can't represent her as a lawyer,
I know,
but
I'm
he
not.
could, yeah, Mr. Marvin wants this to be over with.
I do too.
All right.
Thank you.
Her son steps in, trying to explain that she was just exercising her rights. But by this point, the judge has made it clear she's not just testing the limits. She's walking straight into a much harsher sentence if this continues. And that's the real lesson here. In court, you can be right about some things, wrong about others, but the judge has the final say in that room. If you're offered a way to walk away clean, sometimes the smartest move is to take it.